Hello, my name's Jackie Denham and I'm an associate in the employment team at Field Seymour Parks Solicitors in Reading. I'm delivering a series of 3 webinars about the General Data Protection Regulation, specifically focusing on how you can lawfully process employee data under the new regime. This is part 1 of the webinar series, and we'll be looking at the impact of the General Data Protection Regulation, some of the key concepts under data protection legislation, and then the 6 principles of data processing with which you must comply under the regulation. Our second webinar will be looking at data subjects' rights, the new concept of accountability set out in the regulation, and also why we need to be complying. What are the powers of enforcement, sanctions and remedies available to the Information Commissioner's Office? The third webinar will be a practical session looking at the steps you can take now in order to ensure that by May next year you will be compliant. So starting with the impact of the GDPR. The regulation will be directly applicable in the UK from the 25th of May 2018. There is no need for any additional national legislation to be passed in order for it to come into force. And it will apply to all organisations operating within the EU. It will replace our Data Protection Act 1998. The idea is that it will put in place a single framework applicable across all EU member states, with one consistent set of obligations to enable free flow of personal data across member states. We currently have in place the Information Commissioner's Office, which enforces our current Data Protection Act 1998. And this office will remain our supervisory authority in the UK under the regulation. It's important to note, however, that if you have a presence across different member states, cross-border decisions may be referred to the European Data Protection Board. Similarly, if you operate across member states, you will have one lead regulator, which will be the one where your main establishment is based within the EU. What about the impact of Brexit? Well, there should be very little impact from Brexit. The government has already said that it will not affect the commencement of the GDPR. And in addition, it has published a data protection bill, which will replace our current Data Protection Act 1998 and will implement the regulation standards into UK law. The intention of this is that it will help ensure that the UK will be considered as having adequate protections in place to enable the transfer of personal data outside the EU and into the UK post-Brexit. So let's look at some of the key concepts under data protection legislation. What do we mean by personal data? Personal data is any information relating to someone from which that person can be identified. That means if they can be identified directly because the information includes their name and personal details, or if they can be identified indirectly, for example if it refers to their unique employee number or it refers to other unique information unique to that individual, for example their specific role at the company. So essentially personal data has a very wide definition. It includes personal details, details of someone's family, their lifestyle, their health, education, employment, finances, a huge amount of information. What do we mean by data controllers and data processors? In an employment context, a data controller is an organisation who determines the purposes and means of the data processing, and a data processor is an organisation who processes data on behalf of a data controller. So in an employment context, an employer is a data controller and an outsourced payroll provider is a data processor. What do we mean by processing? Essentially, it is any activity at all that involves personal data. So in an employment context, you're looking at collecting the personal data from the employee in the first place, to storing that personal data even if you're not doing anything particular with it, to then using that personal data in any way at all, right up to the end of the process where you finally destroy the personal data because you no longer need it. Now, the General Data Protection Regulation sets out 6 principles of data processing that all organisations must comply with. The first of these is that lawfulness, fairness and transparency. Essentially what this means is that an organisation must process it no more than absolutely necessary, and that individuals must know exactly how that data is being processed and by who, and there must be a lawful basis for that processing. Now, when we're looking at what information must be provided to an individual about their processing of their personal data, the regulation specifies that it must be in a clear, accessible, easy to understand format. The regulation sets out a whole list of information that must be provided to each individual when their data is being processed. This includes what data is being processed, how it's being stored, why it's being processed, what the lawful basis for the processing is, and what security is in place to ensure that that data is not unlawfully processed or destroyed. We would recommend that in terms of providing that information in a clear, accessible and easy to understand format, you have in place a general data protection policy across your organisation, and also then some specific privacy notices that would go to the individuals specifically. We would think you probably need one for employees and a separate form of privacy notice that would go to job applicants, as their data will be processed in a slightly different way to that of employees. As I've stated before, there must be a lawful basis for the processing of all personal data. Now, there are 6 lawful bases for processing set out in the regulation, but there's probably only 4 of those that are likely to be relevant in an employment context. The first of these is consent. Now, it's important to note that under the regulation, there are new obligations setting out how consent must be given in order to be valid. It needs to be freely given, specific, informed, and clearly distinguishable from other contractual obligations. In addition, if you're relying on consent, the individual must have the right to easily withdraw that consent without suffering a detriment. Now, in the past, typically employers have relied on consent given in a general clause in an employment contract, which would typically list a whole range of very broad terms of how employee data will be processed, and usually then include a catch-all at the end to say that it will be processed in any other way necessary in order to perform that employment contract. Now, that method going forward is unlikely to satisfy the requirements in the regulation about being freely given and being clearly distinguishable from other contractual obligations. The Information Commissioner Office has drafted guidance which specifically states that employers should avoid relying on consent going forward, as there is usually a very clear imbalance of power between the parties, which means that it doesn't satisfy the requirement that consent is being freely given. Another way of looking at it is that if in reality an individual withdrew their consent to the processing, but an organisation would still have to go ahead and process that data, then consent is not the proper basis for processing that particular piece of personal data. In those circumstances, an organisation should be looking at some of the other bases for lawful processing, which I've listed below. The first of these is if the processing is necessary for entering into or performing a contract with the individual. For example, if an organisation needs to provide details of an individual's pay and other benefits to their payroll provider or to the administrator of their pension scheme, then this is likely to be processing that is necessary in order to perform the obligations under the employment contract with the individual. Another lawful basis for processing would be if the processing is necessary in order to comply with a legal obligation to which the data controller is subject. An example of this would be if the organisation needs to give information about the individual's pay to the HMRC, or it needs to store information relating to tax paid by the individual for 6 years in order to comply with their obligations under tax legislation. Another lawful basis for processing which employers are likely to have to rely on is that the processing is in the legitimate interests of the data controller. Now, this is likely to arise, for example, if an organisation is processing employment data in order to calculate its budgets for the following year, or it's processing employee data for business planning purposes. Again, this is likely to be in the legitimate interest of the data controller. It's important that organisations understand, though, that when they're relying on this particular lawful basis for processing, it is open to challenge. If the individual can state that their own rights and freedoms outweigh the legitimate interests of the data controller, they will be able to restrict the processing of their data on this basis. I'd also like to highlight at this stage that there are more onerous restrictions on the processing of special categories of data. Now, these special categories of data are very similar to what we currently understand under the Data Protection Act 1998, called sensitive personal data, and it includes data relating to racial and ethnic origin, political opinions, beliefs, sex life, trade union membership, and the regulation specifies that it now will also include genetic data and biometric data. Now, as I've said before, there are less lawful reasons for processing this particular type of data, and in an employment context, you're likely to have to rely on either having obtained the individual's specific consent to that data processing, which would have to satisfy the obligations and validity requirements I mentioned earlier, or for the processing is to be necessary in order to carry out an organisation's employment law obligations, or if it's necessary for an organisation to defend legal claims, or it's necessary for the assessment of the working capacity of an employee. So moving on to the other 5 principles of data processing with which organisations must comply. Purpose limitation. Personal data must only be processed for specified purposes, and it must not be further processed in a way that is incompatible with those specified purposes. Data minimisation. Personal data that is processed by an organisation must be relevant and must be limited to only what is absolutely necessary for the purposes specified. Accuracy. Any data processed must be accurate and kept up to date. That means that if it is not accurate or kept up to date, it must be either deleted or rectified. Storage limitation. Any personal data must be kept for no longer than absolutely necessary for the purposes for which it was obtained. Integrity and confidentiality. Organisations must ensure that appropriate security is in place for all personal data stored and processed. This must be security that protects from unlawful processing and also prevents accidental loss, destruction or damage to that personal data. So that's the end of my first webinar on the General Data Protection Regulation. Obviously, this is only a brief introductory summary, and you should take legal advice on your own specific circumstances, particularly if you process other types of personal data, for example, data relating to your clients or customers, or if you process personal data, for example, relating to vulnerable adults or even children. There are likely to be much more onerous restrictions and obligations and potentially other exemptions that may apply to your specific situation set out in the regulations. Also take this opportunity to highlight that our employment team at Field Seymour Parks carries out quarterly breakfast briefings. We also can carry out workshops on different employment subjects, and we also issue a monthly e-bulletin on relevant employment updates. If you would like to receive any information about any of these, please email me and I can provide you with this. Also, please get in touch if you've got any questions or feedback on my webinar, and obviously suggestions for any future topics you would like us to cover. My contact details you can find on the slides. And I hope you find this webinar interesting. Obviously, as I've said before, there are another 2 in this series which will give you more information about data subjects' rights, the new concept of accountability, and enforcement sanctions and remedies available to the ICO under the new regulation. Then part 3 will be giving you some more practical tips about what you can do now to ensure you're in a good place next year before it comes into force.